There's different standards in law. I mean, in criminal law, we use beyond a reasonable doubt. It's like absolutely almost has to be beyond any threshold of reason. Why? Because we're sending people to prison. Preponderance of the evidence, the way I look at it, that's what we use in civil cases, like if we have a tort. Usually when we're dealing with money, we're dealing with preponderance of the evidence. It's just probably. Probably 51% or more is how I was taught in law school. Wherever custody is involved, it is by preponderance of the evidence right now. And it does make the trier of fact's job easier. They don't have to be as convinced that something's going on. When you get down, you've had litigants go at it for years, right? Years. $20,000, $30,000, $50,000 thrown out with lawyers. Trier of fact has a 2-day trial, and their decision comes down in writing to a page a lot of times? They don't have to do any more work than that. And then allegations are thrown out there. Under preponderance standards, he abused a child. If it's by preponderance of the evidence, mom really doesn't have to, or dad doesn't, it can go the other way too. Dad doesn't really have to say much to get beyond the preponderance of evidence. It's just his or her testimony. When all my burden is only preponderance of the evidence, I'm really never going to win that on appeal. I have nothing to bite into as the lawyer going in. With preponderance of the evidence on an appeal, I'm done. Trial, I'm done, unless there was some egregious error by the magistrate. Clear and convincing, that threshold, which is what we use in dependency cases, by the way. When the state's coming in to take a child, we have to use clear and convincing evidence. We go in and mom and dad fighting it out. It's just by preponderance of the evidence. What is the difference? I mean, you're severing, a court stepping in and severing a parent-child relationship. I don't care if they think they are or not. 8 days a month, that's not adequate. So what I think, clear and convincing will do, I think we're going to have a lot of cases that they're going to be more factually based. In other words, we're really going to have to put the facts in front of the court. The court's not going to say, well, this is pretty standard. Any client of mine is going to at least walk in and say, hey, I got a fair shake at this. This is what the law says. And guess what? She can't just go in and say I'm a bad dad. She's got to prove it by clear and convincing evidence. That's the biggest thing. I don't understand why it's not used across the board when we're dealing with kids and basically severing parental contact. Okay, maybe not completely, right? Because maybe dad can get the child 6 days a month, or mom can. But we're doing that it's probably true.